So, who has used a land trust or owns property in a land trust right now? A couple of people. So I'll start off by telling you some more of the advantages of a land trust, so you would see why you might want to use one. And then if we have time, I'll explain more of the mechanics of how to prepare one. And then I will add in some tips and tricks about how you can get a little sophisticated with them. So I'm going to jump into what's normally at the end of the lecture. So here are some things you can do with a land trust. So first of all, if you own any real estate in Florida and you die, you will have to probate your estate. So probate is a lawsuit, and it takes several months. So let's say it's a commercial property. Well, the probate is being done, and until an administrator is appointed, your property cannot be managed because there is no owner until an administrator is appointed by the judge to administer your estate. So that is a delay in operations. It's expensive and it's time consuming. So if you put the property in a trust, then the death of the beneficiary has no effect on title. So in that trust, you're going to name a successor beneficiary. So number one, the title doesn't change at all. The fact that you died doesn't have any effect on the real estate. So if you left it to your wife or your kids, the beneficiary would just pass along to the successor beneficiary. The title would remain in the trust. So there's no deed, there's no administrator, there's no deed from the administrator to the heirs. It's all going to stay exactly the way it was. No expense involved, no time delay involved. So if you were a snowbird and you had investment property in Florida and you died in New York, you would still have to probate your estate in Florida. So if you put that property in a trust, you would avoid that. The ownership would pass seamlessly from one owner to the next. All right, creditors claims. So if you own a property in your own name, John Smith, and you have multiple properties, and you get a building code violation, and the city puts a fine of $1,000 against John Smith, that fine attaches to every single piece of real estate owned by John Smith. So this actually happened to me not too long ago. I was representing a buyer at a closing. The seller was a realtor that owned a lot of property. It was in Palm Beach. On one of his properties, he had gotten a fine for parking an unlicensed vehicle in the yard. So that was a $500 fine. But what was pertinent to this is that that fine attached to every piece of real estate he owned in Palm Beach County. So even though my client was buying a different property, he still had to pay that fine off. So the problem was that he might have wanted to fight it or try to get it reduced, but he didn't have the time, so he had to pay the fine at face value, only because every piece of real estate he owned was owned in the same name. So a fine on one is a fine on all. So let's say you get in a car accident and somebody sues you for personal injury, a back strain or something. A judgment against you is a judgment against everything owned in the same name. So if you were to put your properties in a land trust, then every property is in a different name. A problem with one property is not a problem to the next property. A problem that you're having isn't a problem against your real estate. So again, a land trust is just a piece of paper. We'll get into the dynamics of it in a second. Okay, for investors, frequently you will do deals where you have partners in the deal. So one way of doing it might be when you buy the property to buy it in the name of John Smith and John Adams and Alex Johnson, so now you have 3 owners on the property. So unless you designate percentages of ownership on the deed, you're all going to be undivided equal owners. So there may be deals where one partner wants to get out early, or people have different shares of ownership, or the contributions might change. If the property was in a trust, the deed is in the name of the trust, and then in the trust you have the different beneficiaries. So the deed is going to stay the same, it just says the trust owns it. But inside the trust is the beneficiary, so you could say that Alex Johnson has a 10% share and Edison Gonzalez has a 40% share. So you can designate the share ownerships in the trust, and you could even change it. So let's say Edison says, okay, I want my money back out of this property, cash me out. So rather than having to deed the property to the remaining two partners to get rid of Edison, I could just pay him off and then change the beneficial interest of the trust to say now we're left with two partners that are 50-50 owners. So that could be altered without recording a new deed. So I can change around the beneficiaries as I see fit. I could even sell the property to somebody without a deed by just assigning them my beneficial interest. So the property could go from one person to the next without any deed being recorded at all. I was talking with our hard money lender about how land trust could be used to the benefit of a lender. So let's say that somebody comes to you and they want to borrow money against a piece of property. And you're not Citibank, so that money is important to you. That's your personal money, and it's going to mean a lot if you lose it. So to really protect yourself, rather than just giving the person a note and a mortgage that would need to be foreclosed in court. And this happened to me during the bubble. I got into the hard money game and lent out mortgages, and of course, when everything dropped, I ended up having to file a foreclosure against the borrower. It took 8 months, even though I'm an attorney. And of course, what happened the day before the auction? You declared bankruptcy. So that was 6 more months of getting it out of bankruptcy. As all that is going along, no one's cutting the grass, so the city came and cut the grass for me, $500 a cut. So, yes, it's expensive to have the government work for you. So they charged $500 a cut, there's nothing I could do about it. I didn't have the right to go onto the property, they put a lien on me. So all this is going on because I took a note and a mortgage, and I can't enforce my rights except by going to court and going through all this, more than a year to enforce my note. So what's the way to do it a little better? So as I was telling Mr. Dolan, the golden rule, he who has the gold makes the rules. So in this case, the rule is that as the lender, you have the borrower deed the property into a land trust. You, the lender, are the trustee. That means you've got the keys to the property. You're effectively the owner. The borrower, who owned it to begin with, then is the beneficiary of the trust. So that means the borrower is still the owner of the property, it's just he's no longer on the deed. You're on the deed. So what happens if he doesn't pay you back? You revoke his beneficial interest and he's gone. So you didn't have to deed anything, you didn't have to foreclose, you were already entitled, you're already the owner as far as the world is concerned. You just snap your fingers and the borrower's gone. It's your house instantly. He cannot sell out from under you, he can't borrow with anybody else. You're the owner instead of the borrower. So you've got 100% control of the property. Now, of course, when he pays you off, then you'll deed the property back to him. So this is something that's only possible to do in a land trust, otherwise the court will not allow that kind of an arrangement. It's considered too abusive. But a land trust turns it all around because when you put property into a land trust, legally the property is transformed from being real estate to being personal property. So it's not real estate anymore, it's goods. So that's why when you don't pay your car loan, the Ford dealership doesn't have to file a foreclosure against you in court. You just wake up and your car's gone. They just take it back. So the same with the land trust. You borrow against the beneficial interest. You just snap your fingers and the beneficial interest is gone. You didn't need to go to court for that.
Great.
The same with lease options. A lot of people, I think even today, that was addressed, the benefits of lease options. So as a lawyer, the problem with a lease option is that the option E now has an equitable ownership of the property. So the lease part of the lease option, E defaults. You're not getting your rental payments anymore. So you file an eviction. Normally an eviction is a very quick procedure. The person is out within a month. But what is the one thing that can't be addressed in an eviction? Ownership. So the county court doesn't have the authority to try issues of ownership. They don't have the jurisdiction. It cannot be done. That is for the circuit court to decide. So what does the option E do to mess you up? When you file the eviction, he puts up the flag, I'm an equitable owner. I have an option to purchase this property, Your Honor. That's the end of the ballgame, because the judge in the county court doesn't have the jurisdiction to even hear the issue. Your eviction is finished. Now you've got to escalate up to circuit court and do a quiet title, which is just as cumbersome and time-consuming as a foreclosure. So now you've got somebody in your house, and you're doing a court procedure that's going to take a year. And who's cutting the grass? Who's paying the insurance? Who's paying the taxes? You are. You're getting nothing in return. So you are in trouble. So how do you get around the problem of the consequences of the option, that you can't evict the guy anymore? And the answer is with the land trust. So what you do is you, again, are the trustee as the investor, and the lease option E is in there, ranging from the trust. But what do you give him with the option? Not an option to buy the real estate, you give him an option to buy the beneficial interest of the trust, which is a good. So now he doesn't have an equitable ownership in the real estate, he has an equitable ownership to buy a good. So there's no quiet title lawsuit, there's no flag of ownership. In fact, he's not even on title. So you've avoided that completely. Now you can go ahead and do your eviction, and you're not going to be stymied by raising that flag. Another thing for land trust is avoiding reassessments. So when you deed a property, as soon as you record the deed, the property appraiser reassesses the property at the reported sales price. So how do you avoid that? The owner puts the property into a trust to himself. So Jack Smith is the owner, he puts it into trust, Jack Smith is the beneficiary. If the grantor and the beneficiary of the trust are identical, it's considered a non-sale. You don't pay any dock stamps, you don't pay 70 cents, so nothing is recorded. Then you sell the beneficial interest to the trust. So no deed is recorded, no flag goes to the property appraiser. You are supposed to pay the dock stamps. Although the government has no way of knowing anything happened, you can send the dock stamps directly to Tallahassee as stamps on an unrecorded instrument, so you've obeyed the law. But the Broward County property appraiser never gets notified that there was a sale, so your assessment doesn't change. Partition. So if you've ever been in a situation where there are multiple owners and they have a falling out, one of the remedies that the owner has, I'm doing one of these right now, a boyfriend and girlfriend split up, so the girlfriend is suing the boyfriend to partition the property because he told her to go pound sand, he's not going to sell it. So now we're going to force him to sell it against his will. So it'll either be sold commercially or it'll be auctioned off just like a foreclosure. So when you have multiple owners of a property, any of the owners can force the property to be sold in a partition lawsuit. Whereas if it's in a land trust, the trust can provide that partition is not available. So there's going to be no forced sales when you have multiple partners on the property. All right, cheaper closings. Once again, you can convey the property by selling the beneficial interest. So how to make that more palatable is you form a brand new LLC just to be the trustee of this property. So you pay your $80, you've got a special purpose LLC, the Doubletree Hotel Trust LLC as trustee. So you sell the beneficial interest, and the buyer keeps the trustee because it's an LLC, you can just switch managers over to them. So the benefit is there's no closing because you don't have to do a deed. That means you don't have to buy title insurance because the title insurance you had to begin with on the trust still is good as long as you don't deed the property to someone else. So if I was to buy a property in my name and quick name it to an LLC, they just cut off my title insurance, because that was to the original buyer. But if I buy it in a trust and sell Edison my beneficial interest, the title insurance is still on that deed, is still good. All right? Since I'm on a tight clock, I'll get into the an interesting thing that Warda brought up that is lecture, which is that there's another kind of a trust. Well, let me back up a second just to make sure you know what a trust is. Because I told you what you can do with it, now I should tell you what it is. The trust is an arrangement where one person holds the property of another. So if this is Edison's bull and he gives it to me to hold on to, I'm his trustee. It's his bull, he's the beneficiary. I'm in possession of it, so I'm the trustee. So I'm holding his property. So how does he accomplish that with real estate? He deeds the property to a trust. So the Alex Johnson, trustee of the Edison Bull Land Trust. And therefore, the world will treat me as the sole owner. Is all it's going to say on the deed is Alex Johnson is the trustee, and then there's going to be the name of the trust, Edison's Bull Trust, dated June 16, 2018. And that's as far as the world has to go. No one sees the trust. No one knows who the beneficiary is. I know that Edison is the beneficiary, but he could call me up and say, hey, Alex, I just sold my bull to Dave Feldman, so I'm going to switch the beneficial ownership. That's Dave's bull now. No one knows that. I'm in control of things. If Dave wants to sell the bull, then he just calls me up and says, please deed this property over to someone else, or he can assign that beneficial interest to yet another person. So what you have as far as structure is you deed the property to the trust, and on the deed you cite the powers of the trust, which says, according to Florida statutes, this is a Florida land trust, and the trustee has the authority to deal with the property, no questions asked. So I don't need a corporate resolution. I don't need to show the title company the trust. As far as the world is concerned, it's said on the deed that I am the trustee. I have the power to do what I want to with this bull. So that's it. No one has to look any further. So that does bring up the fact that you better trust your trustee. No one knows what's behind the curtain. The trustee has sole control. So you don't want to put your girlfriend and then now it's your ex-girlfriend because she's got control of that property. So make sure that the trustee is reliable. So a lot of the times the way you do that is your own trustee. So you could do that in your personal name. The trustee doesn't have any legal liability being the trustee. But of course, by having your own name on it, you've given up the privacy aspect of the trust. If you don't care about the privacy, then make yourself the trustee. A little bit more sophisticated way to do it, and to provide you with a degree of protection, is again to form an LLC to be the trustee. So I could just file an LLC. You know, on sunbiz.org you can create an LLC in about 15 minutes. And you just have that LLC do nothing other than act as the trustee. It has no bank account, it doesn't have any money, it doesn't have a tax ID number, it's just sitting there, it's like a shell. So now if somebody wants to sue, and they sue that trustee, the Edison's Bull trustee, LLC as trustee, sue away. That's got no money. I don't care. So let's say you want to be private. So I formed the LLC and I have Alex Johnson as the manager. So it's pretty easy to figure out that I might be the owner because when you looked up the LLC on Sunbiz, it says Alex Johnson is the manager of the LLC. So I'm not being too stealthy. So here's how you stealth it up, is instead of having a human being as the manager of the LLC, you make another trust, except this time it's a personal property trust. So the manager of the LLC is a personal property trust, which is not recorded. So now I have a document that I keep on my desk that says, Alex Johnson is the manager of the trust and Edison is the beneficiary of that trust. So now it's Edison's Bull, but Edison's name isn't on anything. And when you look up The LLC, it says another trust, but there's no names. So it's a dead-end street. We even had that happen once. Edison was trying to buy a property, and before the closing, the seller stopped returning the phone calls. So they checked in the recorder of deeds, and the seller had sold the property to somebody else out from under the contract. And we're like, who's the SOB that stole my property? But it was in a trust. So we never did figure out who was the SOB that beat us to the punch and bought it from under us. It was anonymous. So if you really want to be anonymous with your LLC, the manager of the LLC is another trust. And then you can keep going like that, like those Russian dolls. That if you really want to get even more complicated, the manager of that trust could be another trust. And it can keep going. The author of the land trust book, Mark Ward, has said, if you just keep a bunch of blank trusts in your desk, you can keep making the trust as fast as the process server is serving you with summonses, because you can just keep changing the manager, and then it keeps going infinite test, completely on. That the manager of that trust is another trust, and then you could even have the trust be in another country. So it goes on, or another state. It just can go on like that until no one can ever get to the bottom of who's really the owner. For most of us, it doesn't have to get that elaborate, but that is a way that there will be no way to ever figure out that you were the owner of any property whatsoever. All right, any questions? Yes.
How do those trusts complicate the taxes?
They have no effect on the taxes, because all the trust is the title holder. So the true owner of the property is the beneficiary. So, like with the example of Edison's bull here, if I was the trustee, I'm not paying any taxes because I'm not getting any money. It's his property, so he would have the choice as the beneficiary of the trust to have it as a single or a multiple member LLC. A single member LLC, or if it's in your personal name, it's just yours. A single member LLC is disregarded on your taxes. It just flows through directly to you. If you have a multiple member LLC, then the LLC has to pay its own taxes. So just because it's in a trust doesn't affect your taxes at all. The trust itself isn't going to engage in any business other than holding on to the property. So it's not going to take rent checks. It's not going to make mortgage payments. The beneficiary is going to handle all that on his own. So it's your choice how you are as beneficiary. You personally, a corporation, an LLC, that's up to you. It's your pick. Yes?
Have you seen a transfer into a land trust trigger the due on sale?
Good question. So under federal law, the deed of a property from the grantor to a trust in which the beneficiary is the same as the grantor is not a sales transaction. So by law, it does not trigger the due on sale clause. It cannot be enforced by a mortgage company as a violation of the mortgage. So that is why the trust is used very frequently in short sale situations. So as you know, sometimes a short sale takes a long time. You don't want the owner selling out from under you and wasting all your time. So typically in a short sale, the investor would go to the homeowner and say, hey, I'm going to try to get a short sale for you and get you relieved, taken off the note. We're going to sell the property, and now you're not going to owe a deficiency. But I'm not going to do all this stuff and have you sell it to the second investor that knocks on your door. So you would have the homeowner put it into a trust. You, the investor, are the trustee, and the homeowner is the beneficiary. So it's not a due on sale violation because he's still the owner, but now you've got control of the title to the property. The second benefit of that strategy is, while all this is going on, you're seasoning the deed. So by the time the short sale occurs 3 or 4 months later, you've been in ownership for 3 or 4 months. Now the fact is that you don't take the beneficial interest until the bank approves the short sale. So after 3 months of negotiating, the bank says, okay, we'll take $80,000 out of the $100 that we're owed. What you do is you do the closing whereby you, the investor, purchase the beneficial interest. So you do a closing where the only thing that happens is the beneficial interest is assigned So no new deed is recorded. You've got your deed from 3 months ago. You mail the doc stamps to Tallahassee, and voila, on day one, you've got a 3-month-old deed. You're ready to sell to a retail buyer, and it's seasoned already. So you get a nice benefit out of it. Yes?
Alex, question on, as a personal property trust, couldn't it be put in the Delaware LLC?
Yes.
This is no
Sky's the limit.
Okay.
The beneficiary, the ultimate beneficiary can be anything you want. A corporation in another state, a corporation in another country, a trust in another country. You can do anything you want. Nobody knows because it's just a piece of paper between the trustee and the beneficiary.
Good information, by the way. If you're refinancing, so there's no mortgage, how do you address banks or your condo associations that discourage you from having a land trust? They may not want to finance you because you've got a land trust for some reason. How do you address banks?
Well, I can't address the ignorance of the bank, but you do have to bear in mind that in a trust you've got, instead of one person to deal with, there's two. So if you were borrowing property in a trust, the trustee would have to sign the mortgage because the trustee holds the title. Don't forget, the mortgage is a lien that has to be granted voluntarily by the borrower. So the person that grants the lien is the title holder. So in a trust, the ownership and title are different. So the trustee signs the mortgage. That doesn't mean the trustee owes the money. It means he has allowed the bank to lien the property. So the bank would then be doing its financials against the borrower, who would be the beneficiary of the trust. Now, Warda, I think, very optimistically pointed out that maybe the bank would screw up and forget to get the borrower to sign the note, and then in which case nobody would owe the money. But I think that's very optimistic. They would make that mistake. But if the trustee was to sign the loan as trustee, the trustee is not personally responsible for anything.
One or two more quick questions.
Could the trust play any role in probate? I mean,
Yes.
other than the
Yes.
not going through probate, I mean, putting something through probate.
Well, you wouldn't have to probate the property because with the successor beneficiary, the property would pass instantly without any court orders. So I would just point out that there's two ways to deal with these trusts. One is to hire a lawyer that understands trusts, and unfortunately, a lot of them don't. And the second would be to get Mark Warner's books. Unfortunately, Mark self-publishes his books, so it's a little hard to find them. But for you guys, it's worth it because, you know, it's $20-something and it has not only all the information, but it has all the documents on the CD. So you're all set and ready to go to do your own trust. So you'd have to hunt him down on the internet. It's Mark Warda, and his company is called Galt Press. So he no longer publishes through a commercial publisher, so you're not going to see his books on Amazon except back from 10 years ago when he was publishing through a publisher. So the book would be Land Trust in Florida. And then the other one is the personal property trust. So if you anticipate doing this a lot, you could start with an attorney to make sure you don't screw it up. And then once you get comfortable with it, you could write the trust yourself. Back in the era of short sales, where I was literally closing nothing but short sales, one of my clients just was writing up his own trust. So he would arrive at the borrower's kitchen table, he had the trust all ready to go, and as soon as they were willing to let him do the short sale, he would get the listing for the property, and he would have them immediately sign the property, deed the property into the trust, and he would record the deed to the trust right the next day. So he didn't leave the house without the property deeded over to him. So he was doing lots of short sales, and nobody was sneaking the property out from under him and selling it to another investor. So,
Did you want to address how this all affects property insurance at all?
yes, good point. So anytime you're changing the title to your property, talk to your insurance company, because there's nothing an insurance company would like more than to deny your coverage. So if the property was insured in the name of Alex Johnson and now I put it into a trust, they would say, oh, well, I guess Alex Johnson is no longer insured. So thanks to the premiums for all these years, we're not going to give you any money. So talk to your insurance company and make sure that the trust is addressed as an insured party. So you want to make sure that if a check is cut, you can cash it. So that means you don't want the insured to be the trust itself, because the trust only exists on paper. So the way around that is to have the insured be the trustee. So you could have the insured be Alex Johnson as trustee of the Edison Bowl Trust, meaning that if a check was issued Alex Johnson as trustee, then I'd sign Alex Johnson on the back of the check and cash it. So sometimes the bank will, or the insurance company will want to have the beneficiary there too. So let's say that Edison was my trustee, they might say Edison Gonzalez is trustee of the Bowl Trust and Alex Johnson. So you might have the beneficiary and the trustee on it. Just make sure whatever it is, you can cash the check. So don't do anything to upset the title without making sure that you're still insured and that when the check is cut, you can